and welcome to my expert series where I bring you trusted insights to help you live well, plan smart, and age with confidence. I'm Kelly Stain, a residential realtor, and I'm joined today by Elizabeth Kalaki, a respected estate attorney here in Wayne, PA, with hers Potts and Potts LLC. Today, we're diving deep into a topic that's often put off, but very essential and important to have: estate planning. So, whether you're retired, caring for an aging loved one, or simply want to ensure your wishes are honored, this conversation is definitely for you. So, Elizabeth, thank you so much for being here. Do you mind sharing a little bit about yourself and your background?
Not at all. Very good to see you, Kelly. And I am very excited to talk about my estate planning practice. I started my practice in litigation in a big firm in Philadelphia, and I really enjoyed doing that. But as I got to be a mom, I decided, hey, I wanted to have something that had a little bit more predictable hours. And I also, besides having children, really took care of two of my parents who were very, very sick on the earlier side. So because of that, I had a lot of interaction with people that were working on things like estate plans, moving and from different places, from their home to a long-term care facility. So I really became more interested in that kind of group of people and community. And I really thought, this is the kind of law that I really want to do. So that's how I got started.
Yeah, that's
I
great.
yeah.
Let's start with some basic questions. So, what is estate planning and who needs it?
Okay. My first answer to that question is everyone needs estate planning. When people hear the word estate, they sometimes think, well, I don't have an estate. I just have a few things, or I don't have a lot of things. But it really doesn't matter how much you own. If you own something and you also have loved ones, you definitely want to have an estate plan. And so, what really every typical estate plan is encompassed by having a will, like we've all heard of, and
Mhm.
then several other documents, which would be a financial power of attorney, a healthcare power of attorney, and often a living will. But everyone usually thinks about a will. And a will, like people sometimes think, what do I have to know or even be able to tell a lawyer when I make a will? A will really is about, who you trust, honestly, to do certain jobs for you when you pass away. Because a will is all about what's going to happen when you pass away. The
Right.
other documents are more that we'll talk about are more about what happens when you're alive. But with a will, you want to kind of make sure that the people that you want to get the things that you own, including money, will go to those people. And then in addition to that, it's how you want them to get the money. Most times it's just say, this is for you, this is your bequest. But if you had a reason that you might be concerned about giving money to someone directly, like a young child or even an older child that might not be great with money, you might want to consider having a trust as well. And we'll
Okay,
talk a
yeah.
little bit more about trusts, but trusts can be actually part of a will. There's a certain kind of trust that can be right inside the will, and that can cover some of the concerns. There are more complicated situations where you might need a separate trust document. But for today, we're really just going to be talking about trust that can be inside a will. But
Okay.
anyway, so a will, you really need to know three different jobs. You have to have an executor. An executor is someone who is kind of like the organizer of taking care of everything. So you want to pick a trusted person and you want to pick someone who, you really think is fairly organized. They're going to work with an attorney usually. They don't have to, but that person would be the one to communicate with the attorney. And the two of them would decide, oh, I'll take care of selling the house. Or, that the person who's the executor might hire you as a realtor to do that part of it. But then the lawyer might say, I'll do the tax returns for the person. And so there's a kind of a conversation about what parts do they want the lawyer to do. So it's sort of a communicator too, that executor.
Does the
People
executor have like know that they're the executor? Are they
It's a good idea once you make a will to let someone know you're the executor of my will, or are you willing to be? It
right?
usually is someone's child, honestly, most times, or a
Yeah.
brother or sister. But we always tell people once they've made their decision to talk to their children or their trusted person and say, I've named you as the executor. And if someone then finds out or becomes the executor and they're in a really busy job, they can, when they talk to a lawyer, they can say, I really have no time to do any of this. Could you do all of
Right.
it? And then the lawyer would take care of more of it. So it's really up to the person. So that's the executor, and that person doesn't necessarily inherit, but could very well. But then the next person that people name sometimes is a trustee, and that person would be for the trust within the will. It wouldn't come into effect until someone died, and then there'd be a trust saying, here's this money I'm leaving for my child who's 30, but that child has been really bad with money. So I'm going to put their brother in charge of making sure that they spend this money wisely and put a trust within the will. And that essentially is just some oversight over the what you're leaving for your children. So, or
Okay.
anyone else actually. So that's like a special person that also would be good with finances and maybe that you really trusted to be a good advisor that could get along with the person you're leaving the money to. And then the last person, and this is really important, but if you had minor children, you definitely want to have a guardian named.
Hmm.
Because if you don't do it and you pass away unexpectedly, the court will name the guardian for you. And you really want to have your wishes followed. And you want to think about it like, who is going to be the right person for my child to have the least interruption in their life if, let's say, in a terrible tragedy, both me and my spouse passed away. So those are the three roles. And obviously, when people don't have children under 18, they don't have to name a guardian. So
Right.
that's what's inside a will. And then you say, who am I going to give everything in my house to? And then everything else, which would be money, bank accounts, houses. So you have two sections where you're saying who will get those things.
Hmm.
And I think I always advise people split everything evenly among your children if you have children, because that probably leads to the best outcome, even over generations. Some people have an issue with one of their children, but most times that is really what works for people. And if you don't have children, maybe it's your siblings or someone that you really trust a lot. So those are the things that you have to decide in a will. It's really not as complicated. You don't have to declare, I own, these are all the things I own. That's
Right.
not necessary. So,
Right. So, I mean,
and
this is all
then
about planning and putting your
it's
wishes in place, which leads to my next question of like, when should someone start thinking about their estate plan, and is it ever too early?
It really is not too early. And I think most people avoid it because no one really wants to think about like when I pass away. No one
Right.
wants to. But once they make a will, I think it gives a lot of peace of mind. And really, no one of us know what's going to happen in our lives. So most people will live long lives, but there are going to be people who might get an unexpected illness. And you want to feel like you've planned well for your life, for the people you love, for your children. So there's nothing wrong with doing it even when you're young, and then you can change it if something changes in your life that you want to. It's not a very difficult thing to change a will once you have it set. So
Hmm.
I would say very early on, but a lot of people put it off. And a good time to think about it is when you get married, when you have your first child, when your children graduate from high school and are over 18, and then some people get divorced. These are times, any life change is the
Right.
really a good time to think about when you might want to do a new will or look at your old will. And don't feel guilty if you haven't done it and you're older, because many people put it off. They think about
Yeah.
it, but they don't do it.
Yeah.
So it's never too late, but try to plan early.
Right. So
But
you kind of touched on it a little bit when you were talking about trust, but what is the difference between a will and a trust? And
okay.
when would someone need either or both?
Okay. For an average person, probably they don't need to have both. And if they did need a trust, they could put it within the will. We call that a testamentary trust. That would be if you had like a child that you didn't want to get a, an inheritance till they were, let's say, 30 or 35 instead of at
So
18.
that's when you
When people,
assign the trustee.
yes,
Okay.
yes, exactly. So, but we do have trust when people need them for specific situations. They're not necessary a lot of the time. I think a lot of people think a trust is everything. If I get this trust, I'm going to be planning everything well, including avoiding taxes and
Right.
like making it easy on my kids. And there is something called a revocable living trust, which is a way of moving your assets out of your estate, which is kind of what would go through a will. And then the person that becomes a trustee might be the person who's inheriting your stuff, and then they already have access to it as soon as you die. It's not like they have to go through
Probate.
filing the will, the court, and probate. So
Right.
there are reasons to do it. I will tell you that many people call us and say, how can I save on inheritance taxes? And the truth is, there's almost no way to do that. If you leave
Darn.
life insurance to people, you don't have to pay inheritance taxes. If you leave a 529 plan, you don't have to pay inheritance taxes, but everything else you do. But there is something you should know, which is that when you leave things to your own spouse, there is no inheritance tax. The rate is
Right.
0%. So husbands and wives usually leave everything to each other. So there's no need for even probate usually at that point. It's just that and then no taxes. But when the second of a couple passes away, and usually they leave something to their children, the child would have to pay 4.5% of the value of whatever they received unless the money came through a life insurance policy or a 529 plan. So it really is, even with a revocable living trust, they may not have to go through probate, but they still have to pay inheritance taxes. So that's an important thing. I think people think a trust is going to solve everything and you still have to pay taxes.
They'll find you, right?
They'll find you. Yes. I didn't just mention, like, when you do an estate plan, you have the will and then you have powers of attorney. And
Yes.
those are really, really important. And it's something that people should think about if they're older. They should think about doing when they're still very healthy and they don't have any signs of dementia. Because once you are along that continuum, the lawyer has to determine whether you're able to sign powers of attorney. If you have too much dementia, you might not be able to. So it's a really good idea to think about having powers of attorney so that if your children need to help you as you get older, that's in place already. And there's two kinds. There's one for your financial documents, things like you're going to your bank for you, signing on like regular legal documents. And then there's one that is called a healthcare power of attorney that only comes into play when you aren't able to make your own healthcare decisions. It's like if you went to the hospital for an operation, for example, and you're not fully cognizant for 12 hours, your child or whoever you named would be the one to be able to speak with the doctor, make decisions if that needed to happen, look at your medical records. So it's very important to have that. Once you're back and fully awake and everything, that won't be true. Your children will no longer have that power until another incident happened or something. And then the last document that a lot of people hear about and are scared of is a living will. And that's really only when you're in an end stage condition or an irreversible coma, like the doctors have done everything. There is nothing
Yeah.
left to do. And whether you want extraordinary means like a feeding tube, if you want, you can make a choice as to about 6 or 8 different categories, whether you'd want them in that situation only. So that doesn't come into play until the very end of your life. But that is what a usual or a normal estate plan is. It's the will, the financial power of attorney, the healthcare power of attorney, and the living will. And really, the last three documents are about what's going to happen while you're alive. They're not, and the will is about what happens after you
But
pass away.
after, right. And you would get them all together at once if you were doing
Most
a will.
people get them all together. It's really a smart idea, actually. I think you can change any of them at any point, and it's not a big deal to do that. But it's something that people often, they get a will, they might forget to get the power of attorney, and then they really need to have it. We just got a call from a hospital, and I'm probably going to go to the hospital tomorrow to help a woman whose husband is really sick. He's still cognizant, but he is going to be going to a rehab, and they don't have a power of attorney, and she needs to sign some documents for him. So I think that it's good to have that done and settled, and then you don't have to worry about it again. And they
Yeah.
last forever. They really, as long as the people who are alive that you name or the beneficiaries in your will are alive, you don't have to change anything if you're good with what's in there.
Yeah, and that was going to be my question, my follow-up to that. It's relevant is if someone already has these in place, what would make it outdated or ineffective today?
Well, I mean, I guess one option, one possibility would be if, let's say, you named your spouse to be everything, like they get everything that I own if I pass away, and then also they're going to be my power of attorney, and then your spouse passes away before you, then you need to update your documents
Yeah.
so that you have someone that will stand in for you and you'll know where the assets are going. It is a good idea when you get divorced to redo your documents. You don't have to rush in, like the court will act as though your spouse has passed away in terms of if you have named them there and you're legally divorced with a full legal divorce decree, you will not be giving your spouse anything. They will not stand in for you as an agent. But it's still oftentimes necessary to put the person in that should be in those places. So
Yeah.
you would want to think about it then.
Yeah, that makes sense.
Yeah.
What's the difference between you've mentioned a power of attorney, a POA, and a guardianship? When is what's the
When
difference
is
and
that?
when would you use which one?
Okay. Well, when we talk about guardianships, that's getting into an area called special needs planning, something that our firm, which is by the way called Her Pots and Pots,
Yes.
and that we do special needs planning as well. And there's two groups of people that might need that special needs planning. Parents who have children with autism or other intellectual disabilities. I know sometimes with autism, people are very high functioning, but there are also a category of people with autism that really need help. So, and then there's older people. So getting back to the POA again, it's a really great idea for anyone to have a POA. But if you're talking about like parents that have disabled children, you definitely want to have that done. And whether you pick a guardianship for that child after 18 or POAs depends on what part of the spectrum the child might be on. If the child is high functioning, a POA is probably the right way to go. If the child is really not making any decisions, you have to go to court and ask for the guardianship over your own children because you've had that till they're 18. But once they're 18, they need help. Now,
Right.
sometimes with older people, um, you know, if if they haven't done a POA, you might have to go to get a guardianship instead if they have dementia. Another time that people tend to like seek a guardianship for their older parents is when there's fighting among the siblings about money. One child might think that, my sister is not using my mom's money for her benefit, but instead using it for herself. So maybe the other sister goes and tries to get a guardianship over their very elderly parent. And those are, we have done those. They're very much more fraught, I would say, with emotion,
Yeah.
but it is a way to protect an older person. If and the court would be the one to decide, hey, who's telling the truth here? And then whoever is granted guardianship would have all of the rights of the person themselves to run their life, essentially, help decide where they lived, what happened with their finances, things like that. So if it was the person who is really trustable that is doing that, that's great. But there are some family fights that happen occasionally.
Yeah,
So
and having, sold estates and been involved with estate properties and working with the children and executors, thankfully, most of mine have been very like good transactions,
with
good
families, right?
experiences, but sometimes they're not. So what strategies can help prevent family disputes after a loved one passes?
That's a really good question. I think that, what you do, Kelly, the fact that you are helping people downsize, I mean, that can already help fewer disputes because the person, while they're still able to make plans and maybe decide, I'm going to downsize a little bit, that might make them feel like they're in control of their life. They get what they want to do, they make the decisions, and then no one else is making them for them about how they want to age and where they want to live as they age. And so that I think that just being a planner ahead of time is a great way to avoid family disputes, but also having legal documents in place. So those documents are really your wishes. What do you want? And not what your child or the brothers or sisters that are fighting want, but what you yourself wants. So in a way, you're giving your child a gift, or your children. I'm telling you what my wishes are, so you don't have to fight over it. And I think that's a really good way to do so, pre-planning.
Yeah.
um, a lot of people have parents that, they know they should be moving to a safer place to live, leaving their house, moving into possibly a continuing care community. But a lot of people who are older, they don't want to go there yet. They don't want to say it's time.
Mhm.
And it's hard when children suggest this to
Yeah.
their parents, but sometimes even meeting with a lawyer or a realtor to say, like, what are the stories we know about when people don't do that, and what are you possibly trouble could you possibly put yourself in without making those steps that might come better from another person, is what I'm trying to say.
Right. A
That might
third
really help
party.
convince. Yeah.
Right.
Like maybe even just encouraging your parent to talk to a realtor, not necessarily we're decided yet, but we're
Yeah.
talking about it. Like you'd be a great person for someone to talk to. And then same thing, like if a client or a child called and said, my parent wants to come in, and I want to just say, like, I don't know if they're really thinking about the future enough. Like I would definitely make that part of the conversation anyway. Because it is really, I want people to live as independently and in the way that they wish to live more
Hmm.
than anything. That's what really matters. A lot of people will call about their parents, but in the end, it's really their parents that matter and what they want. They are the client, at least in my situation, that I want to help.
Yeah.
So, so I did want to mention one thing that a
Yeah.
lot of people ask, why can't I just do my will online?
Mm.
And we've had a couple of interesting stories lately that I think show why not. Um, but someone did a will on her own, very wealthy person, and she just went online and she didn't really understand that it should be fairly simple about who you leave your things to. So she listed many, many people for various parts of her state. And her executor, who's her cousin, is a wonderful person, but she's been so stressed out by having to follow this unusual document that sort of, there was a format for it, but she didn't really know what she was doing, and it's made that person's life a lot harder. So it is a good idea to consult an attorney and not do things online. Sometimes those online documents are not state specific and might not cover like Pennsylvania laws too.
Yeah. Yeah.
So that's something to say. And also, sometimes people say, well, I don't even need a will. I don't have that much. But another recent story that's worth knowing about is I just had a couple come in and they were only in their 40s. The guy had a good friend just pass away suddenly at 43. He had never been married and he had never had children. So when you don't have a will, the state has a statute called the intestate statute, and it sort of specifies this is what's going to happen if you don't have a will. And they try to guess what most people would want, like the money would go to my spouse or my children. And if you don't have children, maybe you'd say, do you still have parents? So they have ways of figuring it out, like what most people might want. But in this guy's case, no spouse and no children, but he had two living parents, and they each got half of his pretty hefty, estate. But he had not talked to his father since he was 2 years old. But the father still inherited half of what he owned because he had never done a will. So there's reasons to do wills that you might not first think about.
Yeah.
Something
Yeah.
about.
That's a good point.
There are things that we all worry about, and then it's harder to take a step, but sometimes just educating yourself about, what would this really mean to do? It's not as big a deal as you think it would be.
Yeah, it doesn't take too much time. It's not too expensive. Some people think it's pricey. It's
Not really too
not
expensive. I mean,
expensive.
I certainly love to hear from anyone that wants to call me, but also I encourage people call several different law firms and ask what the prices are because you're entitled to do that. No one people have to be told what's charged for each of these documents, or for like we do a flat fee for all four, and they're allowed to compare. You can choose what you want, and I think it's a very smart consumer that does that. So I think it's a great idea. I think a lot of times, just like for a realtor, the person themselves, I believe I consider myself a very trustworthy person that really cares about people. And I know that that's how you are too.
Yeah.
And I think that that is a great way to pick someone, period. Like you want to find
Period.
someone
Right.
you feel comfortable with.
Yeah,
Yeah.
definitely. That's really helpful. Well, I appreciate this. This is super educational. I know
Okay.
we could have dived deeper into many things, but
Yes,
that's
there's
for
always more.
another episode. So yeah, thank you so much for this.
Thank you, Kelly. I really enjoyed talking with you.
I enjoyed it too.
Okay.